Hi, my name is Carl Pearson, and I have an important video which I call Is Chapter 13 Bankruptcy for You? This is video number 68. I defend foreclosure actions throughout the United States, and Chapter 13 has always been something that I tell people that they should look into, and today, actually it was yesterday, I took my own advice and I actually did look into it. I had the good fortune of seeing that the Southern District of New York Bankruptcy Court was holding a meeting open to lawyers in the field and to meet with the judge in charge of all Chapter 13 bankruptcies in the Southern District of New York, Judge Shelley Chapman. So I went down there, and I had the good fortune of meeting with the judge. I met with the clerk of the entire bankruptcy court. I introduced myself to him and said that I'm running for president. And I met the clerks to the judge, the clerk that handles all Chapter 13 bankruptcies, and I met with about 20 or so bankruptcy lawyers. And we had a huge meeting. Refreshments were provided by the court, which I've never seen before in my entire life. That's quite amazing, and I'm very thankful for that. It was a pleasant experience, and I want to report to you because I learned a lot, and I think it'll be very helpful to you to hear what I have to say about this. And I finally learned enough about Chapter 13 bankruptcy to make this video for interested people. And it means almost anyone that's threatened with foreclosure and sale. Now, I'm going to explain how Chapter 13 relates to foreclosures. If you have a foreclosure action that's pending or are threatened with a sale of your property in a non-judicial state, you can stop litigation and stop the sale by the filing of a bankruptcy proceeding. Now, you have to qualify to do that, otherwise you're just getting a short period of time on a frivolous filing. So I want to review with you what Chapter 13 is all about. Now, the Chapter 13 filings occur about 5 months after foreclosures are filed in the judicial foreclosure states, and obviously several months prior to that in the non-judicial states. So when a bank is now threatening in a non-judicial state to foreclose by selling the property, the people that want to stop that might decide to go into court and have to decide between a Chapter 7 or a Chapter 13. So I'm only dealing with Chapter 13 because that's the provision that people use where they, well let me go into that when it's appropriate. The hope or expectation of the homeowner when filing for a Chapter 13 is to remain in the home and obtain some relief from the monthly payments. In many cases, in my opinion, Chapter 13 is overrated and may not be the best route, but you should always make inquiry with a bankruptcy lawyer, 1 or 2 or maybe even 3 of them locally, and determine this for yourself at all times. Always learn what your options are. Now, at the outset, to use Chapter 13, you must live in the property, have 31% of your net income available to service all of your indebtedness. You must obtain a counseling certificate from a court-certified counseling firm, which will cost you maybe $100, and you have to obtain that certificate as a condition to filing. You have to file other papers as well, and you cannot have filed for bankruptcy during the preceding 2 up to 4 years, depending upon the prior type of bankruptcy filing that you had. So those are just the preliminary things that you have to meet. Now, Chapter 13 is often less desirable than a Chapter 7 bankruptcy because it requires you to pay more to creditors than you would pay under Chapter 7. So you should consider Chapter 7 as well when you're thinking of doing a bankruptcy filing. But let me just concentrate on Chapter 13 now. Chapter 13, as I've learned, is most suitable for a homeowner who could pay his or her mortgage before, but then got sick and lost his job, his or her job, didn't have enough money to pay the mortgage, but recovered and is now resuming the employment and can resume paying the mortgage. So that's a classic case where the statute is designed for that kind of person. And it's also helpful if the house is underwater, because if the value of the house is less than the amount that you owe, and if you could eliminate the second mortgage completely, provided that you make payments as promised, which is a big proviso. But you can get rid of the second mortgage in the bankruptcy court, provided you make these payments on a timely basis. And that is something that you have to consider. But that's only if there is no equity at all for the second mortgage. You can eliminate the second mortgage in a Chapter 13, so that's useful. But contrary to what I was thinking, there is no actual cram-down provision in Chapter 13, meaning that the court can't cram down the throat of the bank the value or the amount of the money that's owed, and can't reduce it, in other words, unless the bank consents. There was a provision that was proposed in Congress to give the bankruptcy judge that authority to cram down and reduce the principal amount of the loan in a Chapter 13, but that never was enacted. So there is no cram down provision in Chapter 13. Even if your home is worth less than the amount of money that you owe on the home. So basically Chapter 13 is, in my opinion, just another way of obtaining a forbearance agreement where you pay ultimately everything that you owe to the bank. If you don't pay it right away, they put it on the back end and you pay it later. And because you have to pay back all that you owe, there's a desire for people to file Chapter 13 as readily as possible so that you don't have as onerous a monthly payment, which you would have if you waited several years before you filed a Chapter 13 bankruptcy. Now, in the Southern District, which is not necessarily unique, but maybe more than what the average bankruptcy court is doing, there is a mediation requirement. They call it a loss mitigation session, but that may be because they're trying to find statutory justification for this. But there really isn't any statutory requirement for a mediation session, but several bankruptcy courts, at least several, have been doing it. So I would urge you to, if you wanted to find out whether you have mediation in your own district, federal bankruptcy, look in bankruptcy court mediation or loss mitigation. Those phrases, mediation, loss mitigation, together with your district, like Southern District of New York, bankruptcy, loss mitigation, or mediation, and you'll come up with any program that applies in your own jurisdiction to determine whether there is an effort to try to bring the bank and the homeowner together through a mediation that's a non-binding process. But there is no statutory authority for this mediation, unlike the mediation required in many state courts. But you still need the 31%, by the way. The process does not require you to prove fault on the part of the bank, so that's useful in bankruptcy. You don't have to prove that the bank is at fault, but I put a footnote to that because you may truly want to try to eliminate the bank's interest through an adversary proceeding, which is a lawsuit within a bankruptcy lawsuit. And you could challenge in bankruptcy court whether the bank really owns the note, has title, and is really a proper creditor by an adversary proceeding, which is the same litigation that I do on the outside of bankruptcy court in the state court system. But the problem there once you try to do it in bankruptcy, is that your lawyer is not allowed to be paid. Basically, it's impossible or next to impossible for your lawyer to get paid if he hasn't been paid in advance before the filing of the bankruptcy. It's very difficult for the lawyer to receive compensation for work that's done. You either get paid in advance or you probably will not get paid at all. That's really the difficulty with the Bankruptcy Act. It is just outrageous, to say the absolute least. It is outrageous the way they treat the lawyers for the bankrupt. But that's the problem, so that unless you pay the lawyer $15,000 in advance, there's no way that the lawyer will undertake an adversary proceeding. So you won't have that opportunity usually to contest the lien of the bank in a bankruptcy. And that's why I say that you can do what you do in bankruptcy without proving fault of the bank. The reason is you're not really allowed to prove fault because you can't pay for it. And it's unfortunate, so that you're really better off in the state court system, where that is what you try to do. In the state court system, you try to find fault on the part of the bank and eliminate the bank's lien as a result. But if you do have an adversary proceeding in the bankruptcy court, then the bank obviously will be even more interested in resolving the problem with a loan modification agreement that will probably reduce the principal amount as well as the rate of interest on the loan. So this is what I'm finding out, which I'm now reporting to you. Another point is that upon the filing of a Chapter 13 bankruptcy, an automatic stay of all litigation takes place, which stops any foreclosure action or threatened sale, to give the bankruptcy court time to take control of the matter, and this reduces or eliminates the state court litigation expenses that you and the bank would otherwise be undergoing because of the filing. It's if you give notice to the people on the other side, their lawyers and the sheriff and others like that, then the litigation by law is required to stop, and to violate that is a violation of the federal bankruptcy court order, and it's sanctionable. Now, let me talk about my candidacy for presidency of the United States. I'm seeking the Libertarian Party nomination. It has a lot to do, everything to do with what I've been telling you. In all these videos, we need to do something in the country about the homeowner. The Republicans and Democrats are not doing anything at all. They've given trillions of dollars to the banks, and they've given nothing to the homeowners. They've encouraged the banks to foreclose by giving them a bonus or a bounty if they sell your property, rather than if they give a loan modification agreement in some instances. So the government is not doing anything at all, and the government means the Republicans and the Democrats, who are acting together in doing nothing to help you. The Libertarian Party, through me, and hopefully through any other candidate, but particularly what I'm trying to do, is to raise the consciousness of the political process by raising these issues and putting in ways that we can deal with this through mediation, required mediation in the court system, as I think that I helped to engineer in New York because of a press release that I issued. The court, subsequent to that, issued rules that made it difficult for the bank to foreclose, and that I see results in more modification agreements, which is what we want in order to keep people in the property to pay a monthly amount that they can afford. So here is what I want you to do. This is going to help you, it's going to help me, and it will help 30 million or more homeowners in the United States. I want you to search in Google, put in Libertarian Party and the name of your state, such as Libertarian Party California or Libertarian Party Rhode Island. And then in that website you have to find where they are, where you can download or apply online for membership in the Libertarian Party. I want you to do that. Join the Libertarian Party, and then it's only $15 or $20, but this is very important if you want to participate in this process of trying to stop things. I'll explain further, but your activity is not 1 in 300 million. It's 1 out of 700 people in the country. You are going to become one of about 700 people. You will have a direct, absolute, important influence in the outcome of things. So listen to what I'm saying. This is not 1 vote out of 300 million or 200 million. This is something that is in the hundreds. Very important. You can do something. Here it is. Join the Libertarian Party at the state level in your own state, and find the local group in the county or your city and participate. Ask them tell them you would like to become a delegate to the National Convention to be held at the Red Rock Casino and Spa, Resort and Spa in Las Vegas on May 4th through 6th in the year 2012. We have a nominating convention under federal law, and you, if you're a delegate, and 699 other people, including me, will be there. And we will vote on the candidate for president of the Libertarian Party. If you join, and you join with others who have the same problem, we can have an effect nationally. And I don't see any other way of doing it, by the way. The Republicans and Democrats are doing nothing because, look, they're financed by the banks. They're not financed by the average voter. The banks and their lobbyists are giving them the money. Look who's running the country. It isn't Obama. It's Bush's financial people that are still there running the country, running it down and into the ground. So this is what I want you to do. Remember that. Join the Libertarian Party, get active locally, and sign up to become a delegate at that convention. And if you do, you will be participating at the highest level that you can imagine in the process, the political process in America. Tell others, let others know this is something that you can do. If you don't do it, then you're just writing off the country. Don't write off the country. We can do something about it. This is what I want you to do. So I look forward to this. Let me know. Tell me what you're doing. Call me if you have any questions. My number is 212-307-4444, and go to my website, carlperson.org, carlperson.org. And I thank you, and the country thanks you. So please do something. Do it for me, do it for you, and the 30 million other people involved. Thank you.